Hey gang, Stephen Marshall, KYLandlordlaw.com, back at you with another update, this time legislative update. It's a short session for the state legislature, but things are happening. And I want to talk to you about one today that should be of real interest to a lot of you. So over the last couple of years, you've likely heard a lot of talk, especially coming from the West Coast, about squatters and the idea of squatters' rights. We heard some horror stories out of California about people breaking into high dollar homes and taking up occupancy and tying up the property for years until a court would remove them. And there's no doubt that even here in Kentucky, certain people have attempted to abuse the idea of squatters' rights. Typically, it's someone who's moved into a property with the consent of a tenant, and then later on they refuse to leave, claiming that because they've lived there for a period of time that they now have squatters' rights to continue their occupancy. In rare cases, it's been people who've simply broken into homes and started to live there. Either way, they don't have the property owner's consent to be there, and the property owner wants to remove them. The question is, how can they do that? Well, so far they've had two options, and the first option is always to call law enforcement because without a lease that allows these people to live there or some agreement between them and the owner or a current tenant, they're simply trespassers, okay? People who are on the property with no legal right to be there, and so they should be removed as trespassers. But, as you might imagine, law enforcement is often hesitant to get involved because the squatter, and this will be a surprise, lies, okay? The squatters rarely admit to being squatters. They typically claim someone gave them permission to be there. So, to avoid their own liability, law enforcement simply tells the owner, look, this is a civil matter and you need to evict this person. That leads to option number 2, filing a forcible detainer complaint with the courts to evict the occupant. But that leads to questions about whether the occupant has to be given a notice to vacate, and if so, how much notice must be given. And again, this starts extending the time frame out where the owner is without his property. Thankfully, the state legislature is attempting to give property owners and law enforcement some legal backing to remove squatters without unnecessary delay. Republican Representatives Emily Callaway from Louisville and Steve Bratcher from Elizabethtown have sponsored House Bill 250 to address this scenario. And House Bill 250 allows a property owner to request that law enforcement immediately remove a person who is unlawfully occupying their residential property or any other structure on a residential property if these 7 criteria are present. Okay, all 7 have to be present. The first is that the property being occupied must include a residential dwelling somewhere on the property. Now, the occupant may not be staying in the residential dwelling. They may be in a garage or a shed or something like that, but the property qualifies if there's a residential dwelling on the premises. Second, the unauthorized person must have unlawfully entered and is unlawfully remaining on the property. Third, the property was not open to members of the public at the time the unauthorized person entered. Fourth, the owner has directed the unauthorized person to leave the property. So you can't go directly to the police as soon as you learn that they're there. You have to direct the person to leave first, and only after they don't leave may you go to law enforcement. Fifth, the unauthorized person must not be a current or holdover tenant pursuant to a written or oral rental agreement authorized by the owner. So there's a lot going on in that sentence, but it is a necessary criterion. Six, the unauthorized person must not be an immediate family member of the owner, which is defined as a spouse, parent, sibling, child, mother-in-law, father-in-law, son-in-law, daughter-in-law, grandparent, or grandchild. If it's any one of those people, law enforcement is not allowed to remove them. And then seventh, there must be no pending litigation related to the property between the owner and any known unauthorized person. So those are the 7 criteria that must be present. And if the situation meets all 7 criteria, the owner may fill out and complete under penalty of perjury a new form that they're going to create requesting that law enforcement remove the occupant. And law enforcement means the local police, a local sheriff, or a local constable. Any of those constitute law enforcement, and they can remove the occupant. So the owner fills out this form, signs it under penalty of perjury, gives it to the law enforcement officer, who then must verify ownership. Okay, so presumably they're going to check the property records, perhaps the PVA records or a deed or something like that. And they will also check the ID of the person presenting the petition. As long as they can verify ownership, law enforcement is to serve a notice to immediately vacate the property and return possession to the owner. Now, the good news is law enforcement may arrest any occupant for trespass, outstanding warrants, or any other legal reason, and they will have immunity. Okay, law enforcement officers will have immunity as long as they act in good faith in accordance with the terms of this bill. That's been one of the things that has kind of prevented law enforcement from getting involved, is they're worried about getting sued because the person, they remove someone and they later find out, oh, this person did have an oral agreement, or they did have a lease or a deed or a land contract or something like that. This bill would provide law enforcement officers the ability to act first and have immunity later, as long as everything checked out at the time. So that's very important. The bill also creates a claim or a cause of action for any occupant who is unlawfully removed. Okay, they can sue the owner and they can recover possession of the premises, meaning they would be allowed to go back in and reside in the premises. They can recover any actual losses they incurred as a result of the unlawful removal. They can recover from the owner's statutory damages of 3 times the fair market rental value of the premises, as well as any court costs and their attorney's fees. Now, they'd have to file that claim within 60 days of the removal. So you don't have to worry about them coming back 6 months or a year later and filing a claim. It's got to be done within 60 days of the removal. But those remedies are pretty substantial. So if you're acting under this provision, you better get it right if you're an owner. And then the last part of the bill creates a new criminal offense for anyone who presents a fraudulent document that purports to be a valid lease, deed, or other such instrument. Okay, that offense would be a Class A misdemeanor, which is punishable by up to 1 year in jail. And so the thought is that would deter these occupants from just writing up some type of a lease or a deed or land contract and forging the owner's signature on it. So House Bill 250 looks like a fantastic resource that's going to help property owners get their properties back from squatters in a timelier manner. But there are several questions that we need to think about how it's going to be applied, and as this bill moves forward, potentially changing some of the language. First, what's it mean to have unlawfully entered? Is this going to cover a guest who was given permission to stay for the weekend but then refused to leave? Because they lawfully entered originally. Is that going to cover that person and allow law enforcement to remove them if they overstay their welcome or they overstay permission? And then second, would the bill allow removal of a person who came during an open house when the property was open to the public but later refused to leave? Okay, because that's one of the things that is a criterion is that they could not have entered during a time that the property was open to the public. So would it cover someone who came during an open house and just set up shop and refused to leave? And then third, will law enforcement officers remove occupants who claim to have an oral rental agreement with the owner? Because that's exactly what's happening now, is that these occupants say, well, the owner told me I could stay here. The owner told me I could stay here for, month to month or whatever, and then law enforcement doesn't get involved because of the claim of an oral contract. Hopefully this won't be a deterrent, since the officers now have immunity if they're acting in good faith. And then fourth, who agreed to exempt in-laws from being removed? All right, that's a bad joke for me. So although the devil is always in the details when it comes to pending legislation, House Bill 250 seems to be a fantastic bill for property owners and managers. If you agree, I'd encourage you to reach out to your state legislators, let them know to support this bill and to push for it to move forward. It's currently in committee, just introduced on Tuesday of this week, I think. So that's it for today. As always, if you need help on anything, shoot me an email at smarshall@sslaw.com. If you need a lease package, I've got you covered on that. I'll be glad to let you take a look at it before you purchase. So that's it for today. I hope everybody's doing well. Cheers.